from them, let's say I lend that 100,000 on a million and I'm in first place. Can I stop someone from going and borrowing the other 900,000? What does that look like, Ryan?
Yeah, you could. And you've seen a lot of institutional lenders do this. Like a lot of the banks and credit unions are now putting prohibitions within the mortgage commitment with their borrowers to say you can't get second mortgages or subordinate mortgages without the prior written consent of the lender, right? So it's really just terms within the agreement.
What is up, YouTube? In today's video, we're going to be talking about private lending. I'm really excited to have Ryan from Carson Law on the channel again, and we cover a lot in this video. And in fact, I don't think I've ever heard someone go as in-depth into the different types of security or collateral you can have as a private lender when doing your real estate transaction. Again, I'm just so appreciative of having Ryan on the channel. And in fact, if you pay close attention to today's video, you're going to hear a moment where I actually learned something that I had no idea about because it's only a couple months old. And so that's what I love about bringing on these experts onto my YouTube channel is really, it gives me an opportunity to learn, but also an opportunity to share with you guys what I've learned from these amazing experts. So again, make sure you really pay attention to all of Ryan's wisdom because he sees this every day as a real estate lawyer. Absolutely important that we're going to professionals on these really important decisions. So we're going to cover a ton of information on private lending, but let's just jump into it.
What is up, YouTube? Matt McKeever here, and I'm really excited for today's video. We've got Ryan back from Carson Law. Hey, Ryan, how's it going?
Hey, guys, how's it going? Thanks, Matt.
Yeah, it's great to have you back. And so I'm excited to just jump right into today's subject matter, which is private lending. And so a lot of people, when they think about real estate investing and they're brand new to it, they only think of like buying a property, rolling up the sleeves, swinging the hammer, being the landlord. But there's actually a lot of people investing in real estate without necessarily owning the real estate. And a common structure for that is private lending to the more active investors. And so I'd love to just kind of explore with you, what should I be taking into consideration if I'm thinking about lending money to a flipper or a BRRRR investor or a long-term buy and hold investor? What sort of loan agreements do you see? And, are there certain templates that you recommend to your clients? Let's just kind of lay out the framework for me.
Sure. And just like any real estate investment or investor, it's always very case specific. Some people are much more systematic in their approach and content and document heavy. And then other people are maybe a little bit less so, and it's a bit more fly by the seat of their pants, or it's a little bit lighter on the paperwork side of things. But it all usually boils down to, what's the appraised value of the property? What's our loan to value LTV here? And what security am I getting? Am I a first? Am I a second? Am I a third?
Yeah. And do you mind maybe just elaborating on that security in case someone's not really familiar with lending? What are kind of the types of security and what does that really mean?
Yeah. So, the principal one is going to be a charge or a mortgage. They call it a charge in Ontario. That's how it's registered with the land registry office. But your charge is your mortgage security document that gets placed against the ownership of the home. So, if you and I are involved in a transaction and I'm lending money to you against your ownership at 123 Jones Street is going to be a mortgage payable to Ryan Carson for $100,000. And then it would lay out the terms of what our arrangement is, like interest rate, frequency of payment, payment amount, term of the loan, like so how long, when does it mature, and whether it's interest or interest and principal payments. And then, is there an amortization period, right? Is there an amortization schedule that goes with it? That's the primary form and source of security is a charge, right?
Yeah.
But depending on the type of borrower and the type of deal, there could be other additional forms of security. There could be like a collateral property, meaning it's not just the one property that we're mortgaging 5, right? So it's really being used to buy one property or refinance one property or what have you. But to make the deal work, We also needed to register it against other properties to have collateral security, is what we typically call it, right? To make the loan to value ratios in the deal be appropriate to the person who's lending, right? But then there would be other securities like guarantees. So guarantees are typically used when you have a corporate borrower, right?
Yeah.
So if it's a corporation that's lending money, I mean, unless you're lending to somebody like Coca-Cola or Nike, where you know, like, hey, this is a very like successful business. It's not going to just disappear on us overnight. We can just, you know, have the corporation sign, and we know that it'll be good to pay us back, right? Or if we need to enforce, we can collect against this company. Most people are dealing with people who have a private corporation, you know, Matt McKeever Inc. or Ryan Carson Corp. I mean, these are obviously privately held companies that could be doing really well and successful, but they're private. So the bottom line with those is you don't want to just take the corporation as your corporate borrower on your mortgage. You want to get a guarantee of all the directors and or shareholders typically of the corporation. So all those people are personally on the hook now too. So the corporation's on the hook, but also all the shareholders personally are on the hook too. Another form of of security that would go with this, typically again in a corporate situation, would be a general security agreement. So a general security agreement is an agreement that, in addition to the mortgage, says that if you don't pay or you go into default, we can use the general security agreement, or a GSA, they call it, to go after the assets of the corporate borrower. So not only is the land security for you for, you know, collection and repayment, but now the sale of the corporate assets is on the hook. So if the corporation has quite a few assets, you know, money in the bank, inventory, equipment, so forth, that can be a very valuable tool. I mean, if it's a shell corp, doesn't really have anything other than the one property, the GSA is not going to be that valuable. But you never know over time if it acquires other properties. Well, now all those properties are under the GSA if it's written in that way, right? Another thing could be a share pledge. So similarly with a corporate borrower, you would do a share pledge agreement, which basically states if corporate borrower goes into default, you get to take the shares of the corporation. So you essentially own the corp now. Right. So there's those are a lot of different security options. A lot of them are around more a corporate borrower. You know, if it's just you and I borrowing and lending personally, the most common additional piece of security is typically like the collateral properties. So you pack on more properties to support the higher risk or the loan to value. Those are kind of what I would say we see the most of in a private loan situation from a securities perspective.
Yeah, I love how comprehensive that list was. There was a couple that I had to answer the question I would have totally forgot about. So really appreciate it, Ryan. And do you mind just touching on quickly for the audience, you know, a first, a second, a third charge? You know, what does that really mean? And what's the consequences if I'm in second or third versus first?
Yeah, so I mean, if you're so priority is a word that's used, right? In this context. And so you want to have, if you're a lender, if you can help it, you want to have as top priority as you possibly can, right? Now, one thing to maybe mention right off the bat is the government always has what's called a super priority right to properties. So typically that gives them the right to jump ahead of people's mortgages for collection of things like HST, income taxes, and others, you know, other remittance and deductions that people have to pay, you know, in our country, right? So whether you registered a mortgage in November 2020 and you were a first, meaning nobody else has priority over this property ahead of you. The issue is if this person is also, you know, in financial difficulty and they go in arrears badly on their income taxes or their business HST remittance or both, the government, unfortunately, in July of 2021, could register a government lien of super priority and jump your mortgage. So all is not lost, though, because if you're private lending, you want to make sure you have title insurance. Title insurance's main purpose is fraud protection, but it serves some other purposes. And here is a great layer or blanket of protection for private lenders. Private lenders are now, through most title insurance companies, at least the one that we use most often, which is FCT, First Canadian Title, they have a super priority endorsement that they will now give to private lenders. So if that scenario happens that I just referred to, you can apply through your title insurance provider for the protection the rider gives, which is if at the end of the day you're now short money on your loan because they had to take money out of the property to pay back the government money that's owed, you can apply through title insurance for that shortfall. You'd still have to make all necessary steps to probably collect as much as you could through the usual process of a power of sale or foreclosure or what have you. But if you're still short, title insurance is going to be there to help you under this private mortgage rider of super priority. So there's some great stuff there that didn't exist before. All the big banks have that kind of protection on their title insurance.
Yeah.
But now in 2020, it's just recently been provided in the last couple months on private loan policies.
Interesting. Yeah, I didn't know that whatsoever. So just because I'm curious as well to make sure I understand correctly. So if, I'm going to lend on a property, the buyer buys the property, they get title insurance. Is it that title insurance that covers me, or as a lender, do I need a separate title insurance?
You have your own, right? So typically, unless we can review and vet their policy, because they could put an ownership and lender policy together under the same plan. But if we want to make sure we have premium coverage or whatever, they might try to go only medium coverage or bare bones to keep the cost of the insurance down. Typically, if we were acting as your lawyer for you as the private lender, we just buy you your own, and then we know it's the Cadillac and it's got all the coverages and everything. And if something happens, we know that if there could be coverage, you've got it.
Excellent. Yeah, I appreciate that clarification. And so as a private lender, what are the sort of costs that I'm likely to incur? What should I be aware of as I'm going through this process? And maybe even before getting into that, do I need a lawyer to private lend? At what point in time should I involve a lawyer? Do you mind just kind of exploring that for us?
Sure. I mean, as you and I have talked before, I think the earlier the better. We might say to you, hey, it's a bit early, you don't need us yet. Here's the timeline and the schedule of how we're going to tackle your private loan file. But get in touch with us as early as you possibly can, and as early as you think you need to, because time is the only thing we can't get back, right? So it might be a little early, but we'll set a schedule and make sure we follow it accordingly so everybody's protected. But fees and costs, I think, was your other question. Or part of the question. Almost exclusively in a private loan deal, the borrower pays for everything. So, most private lending arrangements and commitments that we see out there, term sheets, whatever you want to call it, most of them entail that the lender's not out any money. So the bottom line is, yes, the lender's going to have legal fees of their lawyer or mortgage broker fees and whatever the case is. But all of those costs are basically coming off of the mortgage advance. So in a simple example, I agree I'm going to lend you $100,000. there's a lender fee of, let's say, 1%. I'm keeping 10,000 right off the bat, so I'm only giving you now 90. And then let's say there was a broker who negotiated this deal. They're going to take a fee of, let's say, $5,000. So now we're at 85 net advance to you. And then I have my lawyer fee. I would say you should be ballparking somewhere between like legal fees, disbursements, registration, title insurance, HST, kind of the whole thing all rolled in, probably between $2,000 and $3,000 kind of thing.
Excellent.
So, all of a sudden 100,000 actually was a net of, I guess that we're on like 80, 85 or something
change,
like that, right?
yeah.
83 or something. So you unfortunately are losing, lender fee, broker fee, lender's legal fees, like all typically right off the hop. Because of course the lender's like, well, I'm not going to be out anything, right? That's part of this deal. I'm not really paying for anybody over and above.
Yeah.
So that being said, we do see the occasional time where people know, like, well, I need to have like 100,000. Like 100,000 has to be at least my minimum net.
Yeah.
But typically they'll write the commitment kind of the other way to say, okay, 100,000 is going to be the minimum advance, but the registration, what you need to pay back, what you owe at the end of the day, is going to be 115 or 125 because, lender fee, broker fee, legal fees, registration, those all are now out of my pocket on top of the loan. So it's all going to be repaid to me, and it's, I'm just making sure you get a net of what you're wanting. But,
and so let's maybe walk through an example of a mortgage charge, and I'm the private lender. What happens if the person that borrowed doesn't make that a mortgage payment? What's my recourse? How quickly do things escalate? What does that look like?
Yeah, everybody kind of deals with this differently. Some people are like, that check bounces and they call us like that day, right? Other people or companies that we deal with that are lenders, because they're a bit bigger or this is more their, primary business. They have kind of like an in-house group that tries to deal with it before it gets to us. So it's a little bit specific depending on the lender. But 9 times out of 10, the process, whether it's us doing things or the lender in-house doing it, you typically, obviously contact the borrower and say, hey, this is what just happened. Like your check bounced, or I just got a letter in the mail saying like the insurance is being canceled, or I got a letter from the property tax department that says you're behind on your property taxes. Or I got a letter from like RBC because they're the first mortgage and I'm behind them in second, saying, they're going power of sale on you. Like, well, what's going on, right? So first and foremost, typically a courtesy of, reaching out, whether you do it directly or you do it through your lawyer. That's probably the place to start. And the sooner you can do that, the better. Because again, time, only thing you can't get back. And there's certain steps and forms and notices that you got to give. It's not just the passage of time that allows you to like go take a property and sell it. You have to, file and serve and provide notice. And until you're doing all those things, you can't effectively take the property, right? So it starts with like a reach out to the person to say, hey, this is what happened. This is the default. Was it just oversight? What's going on? Hey, maybe you can help them, right? So that's kind of number one. Number two, if you don't get an answer you like, or you get no answer at all, then obviously we would, as a lawyer, with as long as 10 days has passed since the defaults occurred, 10 is kind of a magic number under the legislation, we send an official demand letter to say, hey, you're in default. This is the form of default, bring it in good standing, or our client will give us instructions for next steps under the charge and the legislation. Let's say nothing happens good from that, right?
Yeah.
Or there's no resolution. Then you either have to pick one of two paths. You're either going power of sale, which is probably the more commonly used method, or you could go foreclosure. Most people use the power of sale route because, number one, of the two routes, it's quicker. And by all means, do not think this is quick, right? Like, you're not going to put this thing into power of sale and have the house in 20 days, right? Like, it doesn't move that fast. And it certainly doesn't move that fast now because of COVID, right? If you go foreclosure, it's even like, it's going to be even longer, because the difference is the power of sale derives its procedure and its power, for lack of a better word, from the contract of the mortgage itself and under the Mortgages Act. So it's statutory and contractually driven. Whereas the foreclosure is almost the opposite. It's a court process through like rules of civil procedure and legislation as well. But it's different. It's longer, because the difference here is power of sale. You take possession as an interested party in the land to sell it, to be made whole, hopefully. Foreclosure, you're going through a process to actually take ownership. So it's two different, completely different processes, because the result is different in the end. Power of sale, most banks do it because they're not interested in being, they don't want to own land.
Yeah.
Not in this context, they don't. They just want the property sold to be repaid. Any surpluses under the power of sale, after costs, etc., goes to the person who that was their home, right?
Yeah.
Foreclosure is the opposite. You go foreclosure, your goal is to actually take the home. Like, you want to own the house. In which case, if you suffer a loss, if like that house you thought that was worth 500,000 is only worth 300, well, you're eating the 200. You can't go after anybody for that, right? But you own the house. The power of sale, if you suffer a loss, as opposed to my example of like you kick back surplus, if you suffer a loss, you can still sue them personally under the contract of the mortgage for your outstanding 200,000. So that's probably another reason why you see the banks do that, because they have no way of guaranteeing with certainty that they're going to be able to sell it and get all their money back. So if they go power of sale, they know they can still sue you under the personal guarantee of your loan as well.
Excellent. Yeah, really appreciate you breaking that out for us. And again, just to really highlight, especially the most common path being the power of sale. I think a lot of people in Canada, we often learn a lot of our rules and regulations and laws actually from US TV and stuff like that, rather than necessarily how it works here in Canada. So again, just to highlight, if I'm going to go through the power of sale process on someone, it's not like I win the jackpot. I'm simply going to get made whole.
That's definitely the hope. Yeah, absolutely. That's the hope. You're hoping that your due diligence, when you did the loan in the first place, when you were getting it appraised. And here's probably one thing I've learned that I don't see that many lenders doing, which I think for those that are experienced out there, if you're not doing this, you might consider maybe doing this. If you're new and just starting it, definitely do it. Everybody gets an appraisal done, which is great. Like, you'd be crazy not to do an appraisal, and make it independent. Don't rely on somebody else's. You get the appraiser to work for you and write you the report, because then it's their insurance on the line if they're wrong, right? But get your independent appraisal. But then the other thing is, I would get one or two or maybe even three really competent realtors to give you like an opinion letter as to value of resale, because an appraisal, as everybody probably knows out there, is different than what the market is driving sometimes, right?
Absolutely.
Appraisals are typically, I think, in today's market, more conservative again. So it might be a bit lower, like a lower valuation than, again, what a realtor might give you, or a group of realtors might say, oh, that place is in a really desirable neighborhood. I know it got appraised for 500,000, but it could go for 7. Like 2 houses, on that street just went for 750. So if you needed to do anything short and sweet on this, you'd probably be in a good spot. and again, then you weigh all of that together, right?
Yeah.
To make your decision on the investment. Or the flip could be true. You might get a really aggressive appraisal saying this thing's worth a lot. And you're like, really? Is it really worth that? And then you talk to your realtor and they tell you, yeah, that's probably a little bit high, right? So it's a little bit of a check and balance there. I think that's
Yeah.
important for you, that I don't see too many people doing. And then the other reason to talk to a realtor as well is because they'll have a bit more of a pulse on the area. Like, because you don't want to get possession of it under a mortgage, like under the power of sale, and have in your head, okay, it's already been like 3 months to get to this point of a court order or longer. Now I've got, I've locked them out. I've got the property. We're staging it. We're putting it on the market. Yada yada yada. Oh, and the realtor tells you, yeah, this market, it's like a 6 to 9 month like turnaround, because it's like, rural. This is a unique property.
Yeah, unique's a very common one that I see, where people don't realize the length of time it could sell that unique property with 2 houses on one lot or whatever.
Yeah, exactly. So I think that's an important thing that I don't think too many people are either thinking about or aware of, or both. But I think that's important too, because again, in our previous conversations where we've talked about, why do you need a lawyer? What's a lawyer's value add for you? I mean, it's about the what if and the protection of, when the shit hits the fan, what did we get in place? What did our lawyer get us all registered for to help protect us, right? And make it as easy as possible to, get our money back, right? So
yeah, absolutely. One last question I'd like to touch upon related to private lending. So we won't get into really risk and reward and what's an appropriate reward for a risk, but obviously part of the process of being a private lender, getting that appraisal, getting those realtor opinions, is we kind of want to establish what's the property worth versus what we're lending upon it. And the greater the equity, in theory, the greater the perceived reduction in risk, right? So if I'm lending $100,000 on $1 million property, it seems safer than lending $100,000 on $100,000 property. So if I'm going to be lending privately to someone, can I protect myself from them? Let's say I lend that 100,000 on $1 million and I'm in first place. Can I stop someone from going and borrowing the other 900,000? What does that look like, Ryan?
Yeah, you could. And you've seen a lot of institutional lenders do this. Like a lot of the banks and credit unions are now putting prohibitions within the mortgage commitment with their borrowers to say you can't get second mortgages or subordinate mortgages without the prior written consent of the lender, right? So it's really just terms within the agreement. I mean, you could also register those terms within the charge, but I mean, whether you do one or the other or both, I think it's sufficient. You don't have to do overkill if you don't want to, as long as it's either in your mortgage commitment or in the terms of the mortgage that's registered that says, hey, no secondary financing allowed. Then I think you've done what you need to do to turn around if they do that and say, hey, you're in default right now, so you better find a way to stop this process, or maybe you start down your path of enforcement right then and there, or maybe you have a penalty fee that applies or something. The one thing to be careful about with fees, I've kind of opened a can of worms here, is you really have to be careful, because there's recent law, Court of Appeal law, on this. It's Parcel. If anybody wants, if you Google Parcel, PARCEL, and lawyers' commentary of the Court of Appeal case Parcel, it'll be good for private lenders to do that for their own education. Because even lawyers struggle to try to understand it and make sense of it. And there's really no clarity yet. Like, hopefully there'll be a newer Court of Appeal case in the coming years, or maybe it'll go to the Supreme Court, once and for all, and just say, well, look, this is what a lender can charge for fees. case closed, or this is, you know, where you can't charge anything or whatever, right? Because the problem with what this case does is it indicates that there's certain things you cannot charge. And the courts really like clamped down on, you can't charge fees that penalize somebody, so to speak. Like you can't penalize them and artificially inflate the rate of interest on the loan and so forth. So it's really, if you're a private lender, don't think, hey, I'll go skimpy on like the interest rate and the lender fee because I'm going to smoke them on like a renewal, or, you know, I'm going to have these monster penalty fees. I would do the opposite. I would say, hey, let's be more aggressive with our interest rate and our lender fee, you know, like go stronger with that and be more conservative on your like penalty fees, because those are the ones that people are going to start, you know, or if you have a borrower who's really astute and they have a good lawyer, like they're just going to be banging holes out of that commitment because of this Court of Appeal case on the payout side of things, right? And you just don't want to get into that back and forth. You want your money, you want to get, you know, some standard and approved fees that you can get. But overall, like you just want your money back, right? You want your money back with any missed interest. Of course, that's got to be paid, but it's like the gross, you know, hey, there's a $20,000 penalty fee here, or like there's a 15% penalty because you went into arrears. They're not gonna, the court's gonna squash that, right? Mm-hmm. So you don't want that to be your deal. You know, you don't want to hope they go that way and then hope you get this money and you charge these fees, because I think you're going to find that you're actually not allowed to, right? So Parcel is a good case, or commentary by lawyers on Parcel is good if you're getting into private lending, just so you can understand what fees you can charge and what you can't.
Awesome. Yeah, that's some amazing advice. Really appreciate Ryan. I'll have to Google it myself because I'm not familiar. So again, you're always a wealth of information. Really appreciate you just sharing all your experiences in relation to real estate investing and law. And again, want to encourage everyone on the channel, if you've got any questions, if you're looking at doing a transaction, you know, feel free to reach out to Ryan at Carson Law. We'll throw a link in the video description down below for Ryan and Carson Law's, all their contact information. Again, really appreciate it, Ryan.
Thanks, Matt. Pleasure.
Thanks again to Ryan and Carson Law for shooting this video. Absolutely amazing. I really am proud of just being able to bring this great content. If you guys got value from this content, what I need you to do is smash that like button, hit the subscribe button if you're new to my channel. And if you're already subscribed, ding that notification bell so you get notified the next time Ryan comes on the channel. And good news, Ryan's going to be back.